Our program tonight is focusing on the dangers of internet usage for board members of co-ops, condos, and their property managers, as well as an update on the application process for board members. At this point, I'll turn over the program to Dan Finger. You all know Dan. He is an attorney with Finger & Finger, which serves as chief counsel to the CCAC and the BRI. He contributes articles along with his partners to Impact newspaper, and he produces very, very valuable advice to all of our component groups, including the Apartment Owners Advisory Council and the Co-op and Condo Council. Dan will then introduce his speaker he has arranged, and from there we'll go to Jason Schiciano, who is president of Levitt-Fuirst Associates, insurance manager for the BRI and all of its component associations. Again, many thanks for your attendance. We hope you enjoy the program.
Good evening, everyone.
Good evening.
Ready to start. I'm going to present tonight on the dangers of internet usage. I'm going to focus mostly on email because I think to a large extent the dangers of internet is fairly self-explanatory. Better? Okay. I'm going to focus mainly on email tonight because I think that the dangers of I think the internet itself is fairly self-explanatory. Just be careful what websites you go to. Obviously, you can use the internet in several ways. As I said, mainly I'm going to focus on email. I'll mention blogs a little bit. There we go. Okay, so some of the beneficial uses for email are sending information, board packages. I know a lot of the managing agents probably use it. That's all fine. Online scheduling helps to schedule meetings, interviews, repositories for board data, updating people on issues that don't require actions, online applications. Those are all great uses. I'll get into some security concerns later, but for most of those purposes, security is probably not too much of an issue. Repositories, there are definitely ways of making those type of things more secure. If you have questions on that, talk to your IT guys, how to make your repositories, if you have them, more secure. Okay. The main issues with email, and I'm going to elaborate on each of these, poor communication tool, the hazards of reply all, the fact that it is discoverable in litigation, other legal issues, and then security. Okay, email is a very poor communication tool. It has been shown to slow down relationship building. There is no substitute for face-to-face conversations, for meeting people, for networking. When you get into email, you lose a lot of that. And that goes on definitely at board meetings. As many of you know, you have new boards a lot of times every year. You get new board members every year. Especially with some of the larger, I have some co-ops that have fairly large boards, and so if they get 3, 4, 5 new board members a year, you have to meet those people. You have to get to know people, and it's hard to, there's not really any substitute for actually engaging with people. Also, with email, it's common for miscommunications to happen. And if you're having a conversation with somebody and there's a miscommunication, it's very easy to figure it out and to resolve it right away. With an email, the sender doesn't really know that the miscommunication happens. The buyer interprets something differently, and then it's back and forth, and it takes a lot longer, to fix that and to realize it. You don't have a lot of the nonverbal cues, facial expressions, tone of voice, the reactions from people, things that tell you how they're taking what you say. You're not engaging with people, and that, especially when you're getting into issues that are important issues to the board, things you have to vote on, it's important to have that engagement, that not necessarily one-on-one, but the group engagement so you can, really debate something. The debate over emails is just not really the same. Okay, reply all. I think we've all heard the stories of, the hazards of reply all. You mean to send something to one person, you accidentally send it to, a whole bunch of people. That's obviously, it's not a good idea. It's a hazard. I know there's a lot of times where you don't mean to do it, but even when you do mean to do it, you have to be very careful with it. The recipients, you don't always know who they are. Somebody sends something to you, and especially if there's a number of email addresses, at a glance, you might not realize who all those email addresses are, or who's on it, or you don't see, or sometimes you get an email and it doesn't really have all the email addresses. It has like 2 of them and then ... just to show you that there's like 15 more. So you really have to be careful to look at that and make sure you know, especially if you're replying to all, who you're sending to. And also obviously make sure that you don't accidentally hit reply to all. It's one of those things where you lose control of the message, of the email, of the discussion. The other thing is, this is not just replying, but when you're forwarding, if you forward an email, you're forwarding everything, the whole thread and chain of all the other emails that came before it. And a lot of times people will go back to an email just because they want to send it to 2 people, or they want to send something to 2 people, or whatever, or they want to send one email and they forget that there's like a whole chain of 20 other emails that were below it, and that maybe they didn't want to forward to that person. So you really got to be careful, with that stuff, that you're going to forward information that you really didn't mean to. Okay, litigation, emails are discoverable. Just because your attorney is on an email does not mean that it is attorney-client privilege. Basically, unless the way attorney-client privilege works in this context is if you are asking your attorney for a legal opinion, or your attorney is emailing to you a legal opinion that they're rendering, or questions about that legal opinion, something that specifically has to do with a legal opinion, then it's privileged. If it's and there's even exceptions to that. If it's with people that aren't part of the board, if there's other people that are shared on it, but in any event, that would be privileged. If it's not one of those situations, then it's not privileged. If you just happen to stick your attorney on something, that doesn't make the communication privileged. If you're asking about something that's not an opinion, an update on something, that's not privileged. So those things are, would be discoverable if you get in litigation. That's another reason why email, and it's another context where email is a problem, or can be a problem. And also, you can't unsend an email. Once you send it, it's out there. Deleting your emails doesn't work. There's a lot of rules about deleting emails and preserving emails. If you get involved in a litigation, a lot of times there's what they call litigation hold, where you have to preserve all your emails, all your documents, your communications. Even if you try to delete an email, just because you think you deleted on your end, number one, it's still on the recipient's end. And number two, it could still be on your server, it still could be in the background somewhere, it could be in chains from other emails. Generally, the rule is don't conduct official business over email. Also voting by email, you can't vote by email. There are certain circumstances where there's question about whether or not you can amend your bylaws to provide for that, but the rule would be that even if you were able to, any vote that you would take in that way would have to be unanimous. And so that, it would be, that alone would be very difficult. I generally think that voting by email is a bad idea. Again, there's no substitute for face-to-face debate. It just, with email, it's just not the same. And a lot gets lost in translation. If you have to, you call a special meeting, or you can have a telephone conference call. Something where you can at least hear the other people, or call a special meeting and see the other people. Those type of things are really not going to happen that often that it's that much of a concern. And if there's something that's that important that you really need a vote, then you probably should have a special meeting. You probably should sit down with each other and take as much time as you need to hammer whatever it is out. As far as security goes, I'm just going to mention that there's a lot of factors that go into security, which includes what device you're sending the email from, the security of the device you're sending the email to, who the recipient is, and if you're posting something online, website, there's other issues. If you have attachments to the email, that could also raise security concerns. If you're using a work email, that has some other concerns and other privacy issues or lack of privacy issues which bring other security concerns. Your security at your office or your work is different and maybe more, maybe less than you need. This also backtracks to some legal issues. Things that are discoverable if you're sending stuff from a work email account. That's not privileged. It's now there's a third party involved. It's on your employer's server. It's going through their server. So that's another thing to be aware of. And also, if you get involved in litigation and you send it through your work servers, your employer could be subpoenaed for those emails, and then you have very little ability to resist that subpoena because the employers just turn over the emails. Also, a lot of employers have policies that they have to. They have policies that they're allowed to review your emails, review all of the work products. So anything you're sending that has to do with your co-op or condo is now not privileged and is now could be reviewed by your employer. You may or may not want. You may not care, but you might care. It could be some sensitive information. Okay. Getting back to some of the issues, there's something called a negativity bias in email, when you're dealing with emails and email type communications. And what that means is that typically, if you send an email that you think is positive, the receiver is not going to see it the same way. They'll often, if you think it's positive, they'll think it's neutral. If you think it's neutral, they'll think it's negative. It's always not quite as good. The recipient, it doesn't take it quite as well as you think they will. Again, things I already mentioned. The social cues, emotional signals. Also, a lot of times you might be in an irrational state when you're sending an email. So you start, you get an email, it gets you upset, and you immediately type out the response, and you're outraged or you're annoyed or you're frustrated. You type out this response and you hit send, and then as soon as you hit send, you realize, oh no, I shouldn't have sent that. That was too harsh. So the best thing to do is if you're feeling emotional, write the email, but don't send it right away. Take a breath, take a few minutes, think about it, maybe have somebody else look it over. One thing that I always do when I'm doing that type of email is I delete the email address of who I'm sending it to, so I don't accidentally hit send before I mean to. That way, when I'm ready, I have to actually affirmatively type the email address back in to make sure that, okay, I'm ready and it's ready to go. Just kind of a common sense thing to think about. Misconceptions, things that we already talked about, the attorney-client privilege, they're not covered by attorney-client privilege. You can do conference calls, email votes are problematic, and the expectation of privacy, like I said, you don't have an expectation of privacy, especially if you're doing it at work or sending it from work, any of those type of situations, you really don't have an expectation of privacy. Okay, so interview, do's, have a policy. If you're not sure what your policy should be, talk to your attorney at a meeting, just, and generally have a policy for how you as a board want to use email. And that may change and could change, probably will change every time you have a new board. Old boards, different boards, they might treat it differently. They might want to use it for different things, but at least have a policy and try to get all the board members to, to adhere to it. use it for scheduling, and try to have meetings in person. Like I said, there really, most of my boards, there aren't that many situations where there's an emergency, where something has to be voted on, and if there is, usually it's a good idea to have that in-person meeting anyway. Okay, don'ts. Again, don't vote, not by email. Have a conference call, have a special meeting, something like that. Try not to express opinions on contentious issues. We use email for informing people, not debating. For online applications, like I said, updates, repositories, but try not to get into those opinions or big debates. Don't text or email during board meetings. I've heard of situations where people are, sending things either right from the board or right after the board to people either that aren't on the board, or, texting with other people on the board. It's not a good idea. Some final thoughts. When you're sending an email, an email is a written record. So when you're sending an email, treat it like that. And the same as if you're sending somebody something on paper that you signed and were responsible for. Think about, is this something that you want on the record? Keep your personal emails separate from your work emails. You should not use your work account for your co-op, condo, your board business. Try to have, if you can, try to have a separate account. It's easy enough to get, an email account from any number of places. Make sure your wording's correct. Make sure everything's clear. Make sure as much as you can that it's how you intend to say it. Who are you sending it to? Make sure you know exactly who's going to receive your email. With websites and blogs, that brings up some other stuff that I haven't really mentioned too much, but if you're posting, I know some boards post their minutes online. You don't have to. Typically people are allowed to review the minutes during sales, but you don't have to, but some boards do that, and that's, it's fine if you want to do it, but make sure, if you're going to do that, make sure the minutes that you're posting are redacted, so that anything that has any privacy issues, or anything in executive session, keep separate minutes for that, and don't post that. Post the open parts. If your website keeps organizational documents, bylaws, if it's a co-op or proprietary lease, application form, for condo waiver of right of first refusal form, stuff like that, anything unique to the building, if you're going to do that, you should try to make sure, you should put a password on it so that only either unit owners or shareholders can access those things, so that not the general public can't go onto your website and access it. Anything that you're going to post that you don't want to have a password on should be stuff that's just generally accessible to the public. Pictures of the common areas, list of your amenities, your address, history of the building, things like that. Things that anybody could find out or see. Again, I know I'm repeating myself a little bit, but with your work account, there's no privacy. It's not privileged. It's discoverable. It's you don't really have control over it, and it can, in a lot of cases, it can be reviewed by your employer. That's it. Now I'm going to turn it over to Doug Holtgraver. He's from App Express, and he's going to do a presentation on online application. Maybe you can help me get out of this.
very much for having me tonight. So, my name is Doug Holtgraver. I'm with App Express Online, and we are disrupting the co-op industry with our innovative online application management tool. And don't worry, we do have something coming down the pipeline for condos as well. So, raise of hands, who here touches an application or reviews them or is at least familiar with the process? All right, great. So for those of you who aren't familiar with the process, you generally have volumes of paperwork that's involved, stacks of papers, with lots of personal information. A lot of times this has been emailed around, printed, and it's highly exposed. As we just heard, email can be hacked, it can be exposed online, and it is definitely not the safest form of communication. There are also many financial transactions that you need to oversee. So, the applicant and the seller, they have to pay various parties different fees. And this can be a little bit cumbersome to manage, make sure everyone has all of the right amounts and the checks are all properly cleared and documented. There are a lot of complex communication procedures. There could be up to 10 parties involved at any given point in any given transaction. And everyone needs to stay in the loop. So it's just another layer of complexity with the traditional process. So why App Express? Why an online application? It brings the whole thing online, securely. That's the bottom line. It was developed by cultivating the knowledge of over 40 years of co-op and condo applications. And it was with the assistance of various parties of the process, so we can understand what each of those parties' pain points were and address them. Leverages best practices and applications for New York State. It's a turnkey solution for new entities. So if you have a new entity and you are just developing your application process, we can certainly make that a lot easier for you. And if you already have an application process, it's highly adaptable. We can extend the core application processes, procedures, and documents so that way it adheres to all the standards for you. So some of the key features, obviously paperless applications, automation, communication, and security. So what we've done is we've digitized the entire process. The comprehensive online application will capture all of the relevant information into the system for the applicant to apply to any co-op or condo. It eliminates stacks of papers. You can review the entire application as a downloadable PDF, which you can then print if you still like to read a paper copy. And the biggest thing is the automation. So rather than having to have handwritten documents and have them filled out and submitted, everything is online. Additionally, what we do is with the information that we collect, we're able to automatically perform background and credit checks and have them submitted to the system with proper credit scores and other pertinent information. The collection and disbursement of payments is also automated. So it'll eliminate the need for having checks written, cashed, and tracked. Everything is done online, so you know the right amounts have been paid, and there's instant account verification and fund transfers. Additionally, we calculate and flag any minimum thresholds for credit, debt to income, etc. And this is a very useful tool to be able to pull up a web page and very quickly see your list of applications and who has met the minimum thresholds and who maybe needs to be looked at a little bit closer. Additionally, the online approval process helps to ensure compliance. So, the application coordinator will get the application, they'll review it, make sure it's 100% complete because there is some documentation that needs to be uploaded. They'll review that, make sure that everything is packaged up and ready to go, submit it to the board will review it, make their decision, goes back to the application coordinator, who then has the final approval to send the approval email out. Which leads us to communication. As I said, lots of parties involved, lots of phone calls, lots of emails going back and forth a lot of times. So what we've done is we've kept everyone in the loop at every step of the way. An email will go out when an application is submitted. It will go out when the seller pays their fees, when it's approved or denied, when the board needs to review something. So it's very nice to have everybody on the same page at all times without having to make all those phone calls. In addition to the emails, you can log in at any time. So if you're a board member or an application coordinator, you can log into the system, get a quick snapshot of all the applications in progress, what stage they're at, and review any pertinent information online. Security. So this is a big one. It's something that we hold paramount. All information is transmitted using a financial industry standard, TLS 1.2 encryption with weak ciphers disabled. Basically just means it's highest grade public encryption that you can use right now. Bank information is never stored on our servers. We'll collect the information and pass it along to our processors. They'll process the transaction and the money will be debited and deposited as needed. Additionally, social security numbers never transmitted directly to just transmitted to a highly reputable background check and credit check agencies, and the results are delivered back to us. The copies of the applications, as generated in PDFs, are stored on encrypted documents, so they can't be accessed without a proper encryption key that's paired with them. And all data pertaining to the application is destroyed after 30 days. Unless you have opted for the archival option where we keep a copy of it offline for a further period of time. So, how do you use it? Well, first you sign up as an application coordinator, then register your cooperative, invite the applicants to apply, and let the system manage the rest. So, if you'd like to sign up today, there you go. Any questions?
Sounds like you're taking out one very important step, is the face-to-face interview.
Well, that's part, the board will still have to schedule that, and that's when it gets submitted to the board. They'll schedule the interview, they'll do the interview, and then once they make their final decision, they'll submit it back to the application coordinator with their decision.
I didn't see that comment.
So yeah, I think I mentioned something about that, but we actually do have a scheduling system coming down the pipeline as well to help everyone manage their schedules, which I think will be nice. Okay.
Is it expected that the buyers would enter their own data and their information online?
Yes, they would.
And so the paperwork that they go through now in the package is all automated?
It's all automated, all online. They enter it in. We have a standard set of information that's in forms online in fields, and then any supplemental information that you need in addition to that, you can provide a PDF download for them to handwrite in, answer any additional questions, and then upload with the rest of their documents.
The product seems to be quite mature. How long have you guys been around?
So we're actually in limited release right now. We've been developing it for the last 3 years, and we're ready to go to a wider release very soon.
Is there a way to, instead of getting emails, they can just sign on and chat in that app?
So that's actually a feature that has been in discussion for a while. We're starting to work on it, and hopefully in the not too distant future it will be released. A lot of interesting things are happening. Yes, in the back.
Do you have your, do you want to tell us what your fees are now, or is it on the website?
So if you want, you can go ahead and go to the website, and you can enter in your information, and we'll have someone reach out to you, and we can discuss exactly how all that works and what the fees are. You mean the credit check and everything else, or
No,
the?
not the credit check,
That's-
but the stuff that they put in their financial information, their
Right.
checking account,
Mhm.
their investments, whatever. Do you go back and?
No, we haven't linked any of the. We haven't linked the application to any bank accounts where it can go in and get a snapshot of what their current financial picture is. No, it's the same thing as a handwritten one where it's they put it in. All right. Well, thank you guys very much for your time, and I'll be walking around with an iPad if anyone wants to put some information in, and we will follow up with you within a week and touch base. All right, thank you.
Okay, Jason Schiciano, President of Levitt-Fuirst Associates, Insurance Manager of the BRI and its component groups, is up next.
Is this there?
Thanks.
Oh, that might be a clicker.
I think it might be.
Yeah, oh, it would be nice to have.
Let's see if that works. All right. Okay, good evening. I'm Jason Schiciano. I'm president of Levitt-Fuirst. We're the insurance managers for the Building and Realty Institute and the component councils such as the CCAC. And I appreciate the opportunity to be here tonight to talk about data breach and cybersecurity. I think Dan's comments, maybe you should talk to President Trump. He probably could benefit from some of your advice. I'd like to welcome Associates Pat Clare, Jennifer Apicella, and Rob McComb from my office. Some of you may deal with them. Thank you for being here this evening. Right before I got up here tonight, I saw Jennifer and Robin right before these presentations started. They went to go get a glass of wine, probably because they know what you're all in store for. So hopefully you did the same thing, but probably not. And you should have a 2-page handout with front and back side, very teeny text, because I did not want to have to go to a third page because I'm very environmentally conscious. So I'm sorry if you can't read it, but at least it's only 1 page. The order of the presentations tonight is very apropos because what you've heard in the first 2 presentations is about how to treat data and information properly and protect it. And I'm finishing up with what to do when things go wrong and that protection that you've put in place doesn't happen. So let's discuss it. First of all, you should know that there are some inherent dangers with internet usage, with computers and laptops, etc., and electronic data. The first is that your data can get lost or stolen. Your laptops, your smartphones on which this sensitive information resides can get stolen or lost. Portable information such as thumb drives can get misplaced. Even paper files, which we haven't really talked about and you don't really hear a lot about. Paper files still exist. Many, if not most of us, are still using some paper files, especially in your application process. It's still very common. And you receive documentation in print. So that can be lumped right in with all of this electronic data discussion. It's the same sensitive data. It's just more sensitive now that it's so easy to lose data electronically. We often forget that paper can just as easily be lost or stolen. Also, hacking, unauthorized access to a database. We've heard a lot about this in the news, especially the last few weeks. It's unbelievable. There's a website out there that you can go to actually witness or see all of the attempted hacks that are going on globally, and it's thousands and thousands and thousands a second. It's amazing to see all the flares of attempted hacks on this website. Also, rogue employees or rogue board members, just people looking to cause trouble, disgruntled individuals that want to make a name for themselves or what have you, can be the releasers of sensitive data. There's things called phishing or social engineering out there. This is unbelievable what's going on. And I'm sure we've all received these emails that come to us. They look legitimate or somewhat legitimate, or they look legitimate enough that you click on the link or you click on the attachment, and by then it's too late. Your computer has been infested with the virus that can corrupt the data or hold your information hostage. So phishing and social engineering is growing by leaps and bounds. And then weak data encryption. I'm sure you're all using the TLS 1.2 encryption with weak ciphers disabled that was just talked about, aren't you? Right? Everyone's using that, right? If you're not, then you might need insurance to address that. And then there's poor judgment and lack of care. I mean, Dan was talking about, waking up in a bad mood and sending an email. I wake up every morning in a bad mood and start doing emails, so it's dangerous, right? What are the dangers of internet usage? First of all, unauthorized breach of PII. What's that? PII? Personally identifiable information. What does that consist of? Yell it out. Social Security number. That's obviously number one. What else? Birth date. What else? Driver's license. Bank accounts. What's in a credit card numbers? What's in a co-op applicant's file? Pretty much all that stuff. There's ransom and extortion, which can come in the form of those emails I talked about, where you get an email and all of a sudden you get a skull and crossbones on your computer and it says, your data's been locked up, call this phone number. This is the virus that just went around a few weeks ago around the globe. Call us up and pay $786 or whatever the amount was, and you'll get your data back. They actually usually do give your data back because they have to make it legitimate so that people actually call and pay. But nevertheless, not something you want to be involved with. Destruction or permanent loss of data, you can open up one of these things and your information can just be wiped out. Copyright and infringement. Dan again talked about blogs and websites and what you want on it and not want on it. Those things are dangerous. Sometimes things are said that shouldn't be said or posted that shouldn't be posted, and they're online, and all of a sudden someone has been defamed or some information has been that's copyrighted has been copied. Privacy's been violated. All of these things are dangerous. All right, this one's a little tough to read with the small print. What are the costs of cybercrime and data breach, the things that I've just been talking about? There's a lot of them. First of all, there's hard costs, right? Real money costs. Legal defense, if you are sued because you've allowed the release of personally identifiable or sensitive or private confidential information, or there's an unauthorized transfer that's occurred under your watch, so legal defense and the indemnity to pay for that liability. Regulatory investigations can occur, and there are costs in defending those investigations and responding to them, and fines if you're found liable. There's crisis management. If your association or your co-op, for instance, is in the news and you've got all sorts of negative press out there that you need to combat so that people aren't selling and no one's buying and the value of your property is going down, so the cost of notifications and public relations and reputation control. There's forensic investigation, because if some data gets out, you might be required by an administrative proceeding to do a forensic investigation and find out exactly the extent to which the data has been compromised and who was involved and exactly what records have been breached. And then the requirement for notification. Raise your hand if you have gotten a letter in the mail that says, you are a shopper at Target or Home Depot or whatever, and our data was breached. Your identification may have been compromised. Have you ever gotten a letter like that? Raise your hand. Most people in the room, right? It happens all the time. It's happening more and more each day. So the problem is, when one record is breached, you have an obligation to notify literally every single person in that database of the breach. And if there's information that is involving financial data, you have an obligation to offer, in many cases, credit monitoring for several years, which is another expense. And then, of course, your business may actually be interrupted. It may affect the income to the business, possibly. And then there are soft costs, the cost of time, the cost of productivity, the cost of relationships, both personal and business, and of course the effect on your reputation. So, with all of that bad stuff out there that can happen, what do? I mean, the first thing that you do is don't rely on insurance to fix it. You should try and do the things that these gentlemen have explained to protect the data, to handle it properly, and to manage it properly. But you should strongly consider, if you don't already have it, insurance to address some of the hard costs and soft costs that I mentioned, if in fact the data is breached. So what does that consist of? Cyber and data breach insurance has a number of different types of coverage. The first set of coverages is what is called first party or direct coverages. These are, in essence, reimbursements for costs that you would incur as a board, as an association, as a corporation. Reimbursement for costs for some of the things that I discussed, such as forensic analysis and fees to determine the nature and extent of the breach. Notification that you're legally obligated to do, the letters, the credit monitoring that you may be legally obligated to do, the crisis management to help mitigate the damage to your reputation, the expenses associated with stopping further breaches from occurring, and the cost to restore your data and restore your computer software back to its original state before it was corrupted. The cost for extortion and ransom, which I had mentioned can be costly and definitely affect your productivity until your system's back up and running. And then if you have it, the costs of loss of business income. So those are the first party costs. Those would be costs that you experience out of pocket. And then there are what we would call third party costs, or costs associated with, in essence, you're being liable, you're being sued and liable under the law. And that's liability. And those types of things could be liability for network and information security breach. So your credit card information, your bank account information, your social security number, address, your mother's maiden name, and everything else, goes out the proverbial electronic window, and it's in somebody else's hands, and somebody is using that to open up bank accounts, to take out mortgages. In essence, they can destroy your financial situation. You're going to come after the person or entity that allowed that breach to occur, and you're going to sue them for all of the damage that's been done to your life, to your job, to your financial status, etc. So there can be tremendous liability associated with a personal information breach. There are exposures for communication and media liability. Again, we've talked about publishing information in a blog or putting information on a website that shouldn't be there. So those types of things have liability associated with them for which you may be responsible. And then regulatory proceeding expenses, including fines and penalties and the cost to defend that type of exposure. So cyber liability insurance, or data breach insurance, is an insurance policy. It's a separate insurance policy that you purchase to cover some of these potential expenses from a data breach. These coverages are not included in any other insurance policy that you have, with the possible exception of some fringe coverage on crime, your employee dishonesty and crime policy, which I'll speak about. But in essence, you should just consider that everything that's been talked about tonight and all the dangers are not covered by any other insurance policy except for cyber liability. And a typical cyber liability policy would include coverages that cover the liability exposures to third parties, so defense and indemnity to third parties to which you're legally liable. And that coverage can be as low as $100,000. You can buy up to $1 million or more. And then sublimits, or smaller, lower limits for things such as public relation expenses, which could be anywhere from $50,000 to $250,000, security breach expense, regulatory proceeding expenses. And these policies will typically have some nominal deductible relative to the coverage limits, maybe $5,000. And you can expect to pay for a typical condo or co-op, you could expect to pay somewhere between $500 and $1,500, depending on the carrier, the program, the limits, the deductible, and the size of the account. Meaning, oftentimes these are rated on your income, so your maintenance fees or commons charges. The one thing that I wanted to point out is that there is a distinct difference between coverages under a crime policy or employee dishonesty policy versus a cyber liability policy. So raise your hand if you think your co-op or condo has a crime policy or an employee dishonesty policy. Probably every single one of your entities has that coverage. And that is a critically important coverage, and there are a number of sections of coverage under your employee dishonesty or crime policy. One of them, if you have it, and it's not a bad idea to check because it's not always there. The broker has not always presented that coverage, or again, you may just have employee dishonesty, which covers your property manager or board member for doing something that's dishonest, like stealing. Whether or not they use a computer, if an employee does it, meaning a director, officer, or managing agent, it's covered. That theft, that fraud is covered under the employee dishonesty policy. But if somebody comes in from the outside and uses a computer or other electronic means to steal money, to steal funds, or to commit a fraud in transferring funds, those coverages, funds transfer fraud, computer fraud, are when it deals with the theft of money. That's under your crime policy. Under your crime policy. So you've probably got that policy. You just need to make sure that those very important coverages of funds transfer fraud and computer fraud are there. Okay? It's the cyber liability policy that addresses all of the direct costs and liability associated with theft of information. That's the critical difference. Okay, so then the question really is, with regard to cyber and data breach events, the question is not, will you be a victim of cyber and data breach? But when will you be a victim of cyber and data breach? And it's not, should you have a cyber and data breach liability policy? It's, why don't you have it yet? Any other questions? Yes, sir.
I'm from Realty Management, but I have a question as somebody that's on my board from where I live. We were faced with the same issue, and some of the board members didn't want to pay the extra money for this because they're saying, and I tried to explain it to them in a clear and concise way that they were under this representation that the managing agent who stores the information should be ensuring that and should be absorbing the cost, that if they have an agreement with them, then they're covered. And I tried to explain, that's not the case because as an association incorporated, we're going to be responsible for the service. Could you just expand how I could actually go back?
So this is a great question, which I knew would come up. I didn't thank you, sir, for bringing that question. So the question was, shouldn't the managing agent be responsible for maintaining the cyber liability and data breach policy? And if the managing agent has that, wouldn't that protect all of the condos and co-ops for which they manage? And it's a great question. And the answer is, for $500 or $750, I wouldn't want to rely on it as a board member. And I wouldn't want to put my fiduciary responsibility and obligation to the unit owners or shareholders on the line for $500 or $750. And I think it's very justifiable to spend that money based on what I've said. But the more direct answer to your question is, it's something you need to ask your condo or co-op broker. And they need to coordinate with the managing agent, because of all of the insurance policies that are out there, there's package policies, right? That's your property and your liability, covers your fire or if somebody slips and falls. Those policies are by and large, they're very similar from Greater New York to Philadelphia to Fireman's Fund to Admiral to whoever. They're by and large, they're saying you may or may not have flood, you may or may not have earthquake, but they're pretty simple and easy to understand. The cyber liability policy, absolutely not the case. I've looked at a number of these policies at this point. I've read them cover to cover. They are incredibly divergent in the language they use, in the terms, in the exclusions. So the property manager's policy, if he has one, might cover you. It might not. And actually, you can flip that around, because your association or your co-op is probably responsible under your managing agent's agreement to indemnify the managing agent in a number of cases. So I would say, I'd flip it around and say, how are you going to protect the managing agent if something comes up And he points to that clause in your managing agent contract that says that you're supposed to indemnify him the same way that you have to have your managing agent listed on your crime policy and your D&O policy and your umbrella policy. So, long story short, with all the complexities of the policies and everything I just mentioned with respect to who's liable for what and contractual obligations, I wouldn't want to worry about it for $500 or $1,000.
Can you come talk to my board? You don't want to take my word for it.
I'd be happy to. Yes, sir.
Jason.
Do I need to duck?
Yeah, you do.
Okay, I'm ready.
Once upon a time, people were told that they should have multiple backups of their data sets, and that the backups should be stored in some outside location.
Yeah.
If you get hacked, it seems to me the simple thing to do would just be wipe your computer and regen your whole system. End of story. On the other hand, now we have this new world where people feel safe in using the cloud. So that leads to another question, right? And that is, if an individual decides they're going to buy an insurance policy from you or some other source, will you now come and look over the computer system and say, you can't do it this way, you're now going to have to do it our way?
No, I will not. It's a fair question, and I think the sort of restate that is, if you spend the money and you invest in a cyber liability policy, you get sort of free advice on best practices, either from the broker or from the insurance company. And no, you don't. Insurance companies often give that advice in other types of insurance, right? They come out to your property and they inspect it and they say, you know, you should repair this sidewalk and you need to fix this smoke detector. So it's a logical question to ask. What I've seen thus far, and keep in mind, I mentioned to someone else this is the fastest growing segment of insurance in the world right now, and probably will continue to be for years to come. It is also the one that the insurance industry has the least amount of data to look back on. And that might come, that sort of best practices or a hotline or a review of your systems and how you do things might come, but as you might expect, that would be very expensive to implement. So I have seen with complicated businesses that are heavily tech-oriented, the 10-page application that you have to fill out asks you every question on, do you have this, do you have that, do you have the TLS 1.2 encryption, but not so for condo co-op cyber policies. And why is that? Because the risk is still relatively low. It is. So it's relatively low. The insurance industry hasn't gotten killed on it yet. And so the premiums are relatively low, and once they get killed or once these claims start rolling in and claims get paid out, one or two things or both will happen. Premiums will shoot up, and or they will start to underwrite more closely, which may involve getting into what you're talking about, which is a review or underwriting of the systems that you're using. Yeah.
Can you only get a cyber policy through your current insurance broker, or can you get it?
Well, you can buy a cyber policy from another broker. It's amazing where you can buy cyber policies from. I mean, I always drive. They're advertising them on the radio. They're just piggybacking on this mass hysteria. I mean, you literally. I'm in the car a lot, and I hear advertisements on the radio. The answer is, I would suggest that you buy a cyber policy from the same broker that's placing the directors and officers policy and the crime policy, because there is some, if not overlap, there is some relationship between them all, and somebody should be looking at all three.
Are all brokers providing this?
Those few, you all know there are not a ton of brokers in the Westchester area that specialize in condo and co-op insurance. We're one of them, and we have a number of other good competitors that do it as well. But there's a handful, right? So I think that handful of brokers that are specializing in that condo co-op insurance are all offering this and can provide it. So if not, call me. My number is on the first page. Yeah. Yes, the other presenters are, I think, available for questions as well.
May I?
Yeah, please.
I was intrigued by your presentation because it goes against everything that seems to be trending. Where I work at NYU, for instance, when a vote is necessary for some new policy, even should we keep a student or reject a student, everything is now done by email because it is fast and efficient, and it provides a written record. You said you shouldn't vote. I know that you may be referring to co-op condo, but
Right.
I have to believe that the trend is heading in the same direction. The other point is you suggest that there's more reliability in or recall when you have a person-to-person communication. And that is one of the main reasons why email is so much more effective, because you don't have to rely on, well, you said this, no, I didn't.
No, that's not what I meant.
So that's
Okay,
why-
first of all, co-ops and condos, sorry. Okay, first of all, co-ops and condos for this particular purpose are governed by the Business Corporation Law. And there is a section of the Business Corporation Law that deals with voting and meetings of the board. And that's why particularly, and other organizations, other entities are not necessarily governed by this, but with co-ops and condos, you're not allowed to vote by email. There is some debate as to whether or not you can pass a bylaw to effectuate that. Even if you pass such a bylaw, that bylaw would have to provide that the vote would have to be unanimous. So that's different from a normal board vote. So that's number one. Also, I wasn't trying to suggest that a reason is for recall purposes. I was suggesting that a written record, if you're dealing with something that you might get in litigation over, you might not want a written record. You might not want to have a contentious debate, about, I could think of a few things, about an application or about, whatever, something like that, where, somebody's going to sue you over discrimination, it might not be the best idea to have a written record of what everybody's saying when you're talking about an application that you're then going to get, where that it's an issue and that somebody might come back to you and make a discrimination complaint, because then they have a written record of everything you've said back and forth about that application. So I wasn't trying to suggest that, it's better or worse to have recall. I understand that the trend is email, it's very efficient, it's very fast, and for certain things it's fantastic. But when you're dealing with, those types of issues, it's better to have it face by face. The issue in having it face by face, the benefit has nothing to do with later on whether you'll be able to recall. When you're having a meeting, you can take minutes, but your minutes are not going to document. When you're taking minutes in a board meeting, you're not documenting every word that everybody's saying. You're saying, had discussion about whatever. If there's some particularly salient point that somebody makes that you want to document for whatever purpose, fine. But typically, if you're reviewing an application and you're at the board and you're discussing it, or it could be for whatever it is, but where you're discussing it and somebody says something that maybe they shouldn't have said, you're not going to highlight in the minutes that they said that. And presumably your attorney will be there, or you might ask your attorney if you have a question if something like that comes up, and he or she would tell you, don't base your decision on that, or don't. But the issue, what I was really getting to, was that by having the conversations face to face, you're engaging each other. You're getting the benefit of seeing people's reactions. You're getting an order to the conversation. One person says something, everybody hears it, somebody else says something. Instead of on email, one person might write something and then somebody else responds and it gets read out of order, and it doesn't always make sense. So things then get taken out of context, out of order. Look, and I understand. I mean, I use email as much as anybody. I understand the benefits. I understand, that there's a lot of situations and that's the trend. But, if you take anything out of this, you have to be careful when you use it. You have to discuss as a board what types of situations you want to use it for. If you're talking about the managing agent sending you, the monthly board packages, fine. Maybe you have a policy that you want the managing agent to send it by secure email, so that way you don't have some of those situations of data breaches, or at least you minimize the risk, because you might be, the package might contain sensitive information. It might not, but it might. So you have that policy, and there's a lot of great things. There's a lot of updates, and there's things that that there's no harm. But if you're dealing with something, especially when you're dealing with something that you're going to need to vote on, or a sensitive issue, you have to be careful.
Does that include text?
That includes text, email. I mean, it's all it's all basically the same type of thing. It's all digital communication. You send a text, your text doesn't go away. It's on your phone. It's the same kind of thing. You can try and delete it. You might delete it. You might not. It's still on, whatever server it's going through. It's still on the other person that you texted. It's still on their, phone or device or whatever. Instant message. I mean, those things. Once you write it, it's out there, and a forensic, a forensic IT consultant can probably find much more than you think that they would be able to find. And Doug can correct me if I'm wrong on that, but somebody who's good at that can find a lot of stuff that you didn't think they'd be able to find. Jerry?
My question is to your comments, I guess, about emails that can be used in litigation, that are discoverable, et cetera. Common practice, for instance, in sales of commercial real estate, is that a buyer signs a confidentiality agreement where they can't distribute any of the information that you give to them unless they're interested in buying. So if you preface an email with private and confidential, when you have some sort of electronic signature, for example, could that then make it privileged and not be used in litigation?
No. I mean, just because you're putting privilege and confidential or whatever.
Even with an electronic signature of some sort?
Even with an electronic signature, if somebody subpoenas it and the court directs you to turn it over, you have to turn it over. I mean, it's not, look, it's better than nothing, but it's, but if you're in a litigation, if you're in that situation, and and somebody goes to a judge and gets an order and says, I think he has emails, I want all his emails related to this, if it's relevant, the judge is going to say yes. They're not going to say, oh, well, it says privileged and confidential on the top. If it's asking for an opinion from your attorney, that's privileged and confidential. But you can't put privileged and confidential on every email you send out, so that it's now privileged and confidential no matter what.
Emails may need to be preserved, with the exception of the sensitive ones and the voting ones.
Right.
Normal correspondence between meetings, some of which is probably discussion leading up to a vote at the meeting. Does that have to be preserved? And if it does, should it be attached to the minutes, or is there a special place?
Well, the idea is, if you're involved in a litigation, you have to preserve your emails. You have to preserve your communications, which means don't delete them. Or if you do delete them, then there could be a presumption that there was something in them. The presumption is then against you. But so in a complex litigation or a litigation over it, you have to preserve your emails. My point was that you're not typically, people don't go through their email boxes and every time they read an email instantly delete them. Even if you do, there might still be a copy on the server, there might still be a copy on the recipient or the sender's email. You're not, just because you're deleting it from your actual box doesn't mean you're really getting rid of it. That's really kind of a cautionary, just because you think you're hitting delete doesn't mean it's actually deleting. And then the second part was, if you're in a litigation, you're not allowed to affirmatively delete. So, yeah.
It's a question, I mean, you didn't address it in the presentation, I was just wondering, how about when people blind copy people? Sometimes you have somebody that's they're blind copy.
Right.
You hit reply all, and there are people that are getting stuff that you don't even know are getting.
I don't know that if somebody's blind copied, I don't think they typically would get your reply.
Yeah, they wouldn't get the reply.
Unless you blind copy them on the reply.
Well,
Yeah.
right, but then that would be kind of chance that you happen to blind copy the same person who was originally blind copied. But I guess it's possible, but, right. So,
Any other
Send an
questions?
email to them, or you send.
And Condo,
yeah,
Dan, sometimes you can't wait for the next board meeting to make a decision on something.
right.
So can you do it by email and then ratify it at the next board?
I mean, yeah, if you can't wait till the next board meeting, my suggestion is have a conference call or have a special meeting. You don't have, I would be surprised if I saw any bylaws that didn't have a provision for calling a special meeting. I don't think there are any bylaws for co-ops and condos that don't have some provision for calling a special meeting. Some of them, I have one place where it's like 5 days or 4 days or something, which, maybe change because they feel that that's too long. Usually it's like 48 hours notice, 24 hours notice, but every bylaw has some provision for a special meeting. So, my advice would be to do it that way. I did read a case when I was researching this where a board made a decision by an email vote, they ratified it at the next meeting, and in that particular, it was a pretty, detailed case. In that particular limited circumstance, the court felt that that was okay. I really, if it was something that was big, that was going to have, big financial consequences, I really wouldn't want to be hanging my hat on that. There's not a ton of case law on these particular detailed issues, but, any other questions for me or anybody else?
Thank you.
Okay, as always, if you do think of any questions after you leave, whether it's me or Jason or whatever, you can email Jeff and he'll get in touch with us. Or call us directly.
Please join me in thanking Dan Finger, Doug Holtgraver, and Jason Schiciano for an excellent presentation.